All right, well, let's jump right in. We have a jam-packed session. This is pretty eagerly awaited, and we're excited to have our speakers today. My name is Scott Seaback. I'm the Programs Director for Rhode Island Shrm, and just a couple quick notes. We always want our programs to be interactive, so please take a moment to put your comments and questions in the chat box. We'll be monitoring that throughout the session. Today's program was submitted for Shrm Professional Development Credits and HRCI credits, and credits and information and copies of today's slides will be sent to all attendees about a week after the event. Just a quick reminder on Zoom etiquette, please keep your phones and microphones on mute as a courtesy to our speakers. We've got two upcoming programs. We're very excited to announce that we're going to have a winter social, and that'll be on December 8th at the Guild in Pawtucket, Rhode Island. You can sign up now. The website is open for registration, and our first women-only event coming up the next day on December 9th, Women as Leaders, and that's going to be really great. So, and thank you, Gary Convertino, for bringing that to us. Talk about our sponsors as always, our Gold 2021 Gold sponsors. Their generous financial support has allowed Rhode Island Shrm to continue and to offer timely and informative programs to members like you, and we always thank them. So let's please thank Bryant University's Executive Development Center, College Bound Saver, and the Hill Group of New England. Thank you so much. Today's sponsors happen to be our two presenters, and we're so fortunate to have both of them. We have Epstein Becker Green, and Fran DeLuca will say a few words about your organization, Fran. So go ahead.
Good afternoon, everyone. I'm so happy you could join us today. As Scott mentioned, I'm Fran DeLuca. I am with the technically Boston office of Epstein Becker Green, though today I'm broadcasting live from South County, where I live. We are a national labor and employment boutique. We also have some healthcare work, but I am on the labor and employment side, where I focus exclusively on representing management in all types of L&E disputes, from discrimination, retaliation, workplace safety, restrictive covenant, whistleblowing, and I also work with employers to adopt practices to avoid having to go to litigation.
Terrific. Well, thank you so much, Fran, again, for your sponsorship. We really appreciate it. And our second sponsor, a well-known face to the Rhode Island Shrm community, Christine Cunin, CEO of Higher Image. Christine.
Hi, everybody, and welcome to today's program. Happy to sponsor. I'm Christine Cunin, CEO of Higher Image. We're a nationwide background and drug testing company and nationally accredited. But I did want to sponsor today to just let everybody know, well, first of all, bless all of you for being in HR, because I don't think there's been a, other than healthcare professionals, a tougher position out there. I know you guys have been faced with so much with the pandemic, and now with all these mandates, which is why we're all here today. We did have a lot of clients asking us about collecting cards for the pre-employment screening side of things. So with that, I had a programmer who had developed something in the healthcare space. So we did develop what's called Vax Tracker Pro to help out with this ETS and the OSHA reporting and collecting the vaccination cards. And I know a lot of you have been collecting them anyway or certifying, but we're collecting what type of brand and the dates of last shots, just kind of being some forethought into what if OSHA comes out and says, oh, now everybody needs a booster, or how that's going to go. So we've developed a program so you'll have that easy reporting for OSHA, and then also rolling into the testing and the notifications to employees for via email or text message for testing. So happy to talk to any of you about this outside the program, but wanted to make sure you all knew we had that available if and when this is all going live, but we'll make sure Fran's going into that during the presentation. So welcome, everybody.
Terrific. Thank you so much. Just one thing I want to remind members, we have two social media fronts, both a LinkedIn page and our Facebook page. And I don't know either of them off the top of my head, so I apologize, but I'll put them in the link in the chat box. But we're active on both of those sites, and there's information out there, and we want you to be aware of it. And we are in the community for our social media. And without further ado, Christine, I'm going to turn it right back to you and take over for this afternoon's meeting. Thank you so much.
All right. Well, thank you, Rhode Island SHRM, for putting on this important program. I was asked to moderate with Fran is going to present. He has an awesome slide deck with tons of information. And when we talked about moderating and I saw his slide deck, I was like, why don't you just go through your slide deck? I'll ask questions. I've been receiving a lot of questions, so I have a bunch of them. We have it built into the program here, but also please ask your questions in the chat area, and I will intersperse that as Fran is presenting, but he has tons of information, but I'm just going to be jumping in at that right time with those right questions. So I am not going to waste too much time since there's so much to cover, and I'm just going to hand it right over to Fran, who's going to share his slides, and we'll get into it. So please don't forget, put your questions in the chat box, and we'll make sure we get them all covered.
All right.
Over
Thank
to
you,
you, Fran.
Christine. So here we go. Let me just share my screen. And here we are. So as Christine mentioned, feel free to ask questions. I've tried to tailor our presentation based on the questions that I've been getting from clients and my colleagues across the country have been getting from firm clients. So hopefully I'll answer most of your questions, but like I said, feel free to ask whenever you have one. So let's just go over the agenda briefly. We're really going to talk about 4 umbrella areas. First, I'm going to give you some background on what is an ETS and what does this COVID-19 ETS mean. Then we're going to talk about the December 5th and January 4th requirements. And we're also going to talk about how some recent court rulings impact those requirements. And finally, we're going to conclude with some compliance considerations. And I have a compliance checklist that will be one of the last slides that you can take with you and kind of use as a checklist as you go through your ETS considerations. So let's just start with some background. Most of OSHA's regulations, which is what the ETS is, it's just another regulation, have to go through notice and comment rulemaking. And that is a very time-consuming process. OSHA has to let the general public know, hey, we're rolling out this regulation. How is this going to affect you as an individual or you as a business? And it takes months and months and months to go through that process. Obviously, Congress contemplated situations that might be very dangerous and require some kind of emergency prompt action. So it gave OSHA the ability to issue an emergency temporary standard, or an ETS. To issue an ETS, OSHA has to do 2 things. It has to show that employees are exposed to a grave danger from toxic or physically harmful substances or new hazards. And they also have to show that an emergency standard is necessary to protect employees from that danger. So they have to show this can't go through notice and comment rulemaking. We have to do this now. It's a really high burden. And because of that, OSHA's history in rolling out ETSs is not great. Since OSHA's creation in the 70s, it has only issued 9 ETSs. The last one was issued in 1984, before the COVID ETSs. 3 of them were not challenged, and they went into effect immediately, but the other 6 were all challenged. 1 challenge was outright denied, but the other 5 were upheld in part, or they at least prevented the ETS from taking effect immediately. And so OSHA went through its normal rulemaking process. So under this ETS, we have some key dates that we need to keep in mind. The first is November 4th is when OSHA released this ETS. December 5th is when the first requirements will go into effect. And there really are 3. You have to adopt your vaccination or an alternative test and mask policy. You have to collect employees' vaccination records by then and maintain them. And you have to take certain steps, which we'll talk about, to encourage and promote vaccination among your workforce. After that, on January 4th, their unvaccinated employees must be tested before coming into work. And that's when your employees also have to be fully vaccinated. And on May 5th, the ETS is scheduled to expire. And like I said, we're going to talk about how that's impacted by the court rulings in a minute.
Fran, I know there was some confusion there, but I guess it doesn't matter with the court, the stay from the courts, but the December 5th, December 6th date, because then OSHA came out with their FAQs and said December 6th. So, but I guess it doesn't really matter now.
that is a good point though, Christine. And I'd say that it's highly unlikely that the December 5th or 6th deadline is going to remain in place, but it very well could happen. And we're going to talk about that later. But let's say the stay is lifted. If that happens, there is a question about is compliance December 5th or December 6th. OSHA said this takes effect within, I believe, 30 days of its publication, which was on November 4th. If you do the math, that's December 5th. That's a Sunday. A lot of statutes have provisions that say if a deadline falls on a weekend or a holiday, just push it out to the next business day. OSHA doesn't have that. So technically, assuming the stay is lifted, the deadline to comply would be the 5th. And so you'd have to be in compliance on a Sunday. That said, highly unlikely that OSHA, from a practical perspective, is going to take issue with your complying by, the early morning Monday. I don't think OSHA is going to care. So let's talk about who's covered by the ETS. As a preliminary matter, all private employers with 100 or more employees at any time the ETS is in effect are covered. And I say at any time when the ETS is in effect, because if you have 100 employees as of November 4th, you're covered. If you had 90 employees as of November 4th, but let's say on December 10th, you hire 15 more people, now you're covered. And you're covered even if you go under that 100 employee threshold. So once you hit it, the hook is in, and now you have to comply going forward while it's in place. There are two types of private employers who are not covered by the ETS. The first is federal contractors who are covered by guidance issued by the Safer Federal Workplace Task Force. And the second are healthcare settings that are covered by the OSHA ETS for healthcare providers issued in June. Now, these are not blanket exemptions for an entire employer. Rather, they're exemptions for a workplace or a setting. So OSHA has been very clear that if you are a healthcare provider and some of your operations are subject to the healthcare ETS, you still have to comply with the generally applicable ETS that we're talking about today with respect to your other employees outside of the healthcare setting. And the same is true for federal contractors. If you have a workplace that's subject to a federal contract, that's subject to the Safer Workforces guidance and not the OSHA ETS. But your employees outside of that workplace are going to be subject to the generally applicable ETS. So that is a workplace by workplace inquiry. Now, when calculating the 100 employee threshold, we have to include all employees. And this means full-time, part-time, seasonal, temporary. Anyone who's on our payroll has to be included in the count. We have to include everyone at all U.S. work sites. So if I have a facility in Rhode Island, but I have operations in Connecticut, I have to count both resources or facilities to determine my employee count. And there are two kind of hot button issues that I see in the ETS. And the first is integrated employer. If you are a company and you have either subsidiaries or affiliates and all of your safety decisions and labor management relation decisions come from a centralized source, you'll have to look at whether you meet the integrated employer test that the DOL has been applying to see if you need to count just the employees of one company or if you have to put them all together and count them as one enterprise. Another hot button issue is independent contractors. And this goes back to the Biden campaign, where he specifically said independent contractor relationships are in the crosshairs. One of the first steps that the Biden DOL under Secretary Marty Walsh took was to rescind a Trump era rule, making it easier to classify workers as independent contractors. With that in mind, I think we really need to take a hard and careful look at our independent contractors to see, are they really independent contractors, or is the DOL and OSHA going to say they're employees that should count to the 100 employee threshold? And finally, the ETS does not apply to certain employees, even of a covered entity, under 3 situations. The first is if an employee reports to a workplace where other individuals and customers are not present. When that employee is at that workplace, the ETS doesn't apply. It doesn't apply to employees who work exclusively outdoors, but this has to be exclusive outdoor work. So if they are going indoors and interacting with people, they're going to need to comply with the ETS. And finally, the ETS does not apply to employees while working from home. So we have to count remote employees to our 100 employee threshold, but while they're working from home, we don't have to apply the ETS to them.
And I think, Fran, that's been a lot of confusion for folks of what does the 100, how does the number 100 get calculated? So definitely counting those remote workers, but also we've had a lot of questions that have come up with those that are federal contractors, that it's like, okay, I have 30 that are on a federal contract, and then I have, I don't know, 80 that aren't. So do I fall under ETS for the other? And I know you did cover that, but that's come up quite a bit. But just also letting folks know that we're not covering the federal contractors here today or the healthcare requirements, but those are stricter. So just kind of what they should follow on that. But I did have a question too that came up with that independent contractors. Can an employer choose to include the independent contractors within their, kind of complying with the ETS, or what would your suggestion be there?
So I'd be a little hesitant to include independent contractors because it might make them look like employees,
right?
Especially if these are individuals that you're contracting with as independent contractors. Now, that said, the OSHA FAQs do say that you can apply the ETS's standards, if you'd like, to subcontractors on your work site. But I'd be more comfortable doing that with a subcontractor who's an independent business rather than an individual. I'd want to maintain kind of a hard line between employees and individual independent contractors.
Great.
So just very briefly, we don't have to worry about this too much in the Northeast, but if the ETS takes effect, it will preempt state and local laws to the contrary. So some states have laws saying employers can't ask about an employee's vaccination status. Other states have laws saying that employers cannot roll out mandatory vaccine policies. These are typically executive orders. We don't have anything like that, but if we did, the ETS would preempt it, meaning those state and local laws are not in effect. The ETS does not preempt state or local laws that govern the general public. So if you are an employer, like a retailer, and you have members of the general public coming in, you have to follow whatever executive orders are issued by the governor's office or whatever regs are put out by the Rhode Island Department of Health. And you don't have to apply the ETS to your customers, but your employees will be governed by the ETS.
So Fran, on that, I know Florida just had a special session to have kind of the anti-mandate bills that passed, but it's funny what we read in the media, right? But I mean, there really is no way to say that they can go against the federal OSHA mandate, right? I mean, I read it and I'm like, okay, it's just a play on words, because really at the end of the day, they didn't do anything against the mandate. But so there is no workaround, right?
There's no work. If the OSHA ETS is in effect, which right now it's stayed, but
Right.
if it's in effect, there's no workaround. It will be the law of the land, and the states really can't do anything about it. And so, speaking of that, let's talk about what the ETS requires under the currently December 5th deadlines. Uh, so, as I mentioned, it requires three things, the first of which is a vaccination policy. So, here the ETS gives employers a little bit of discretion. They can adopt a mandatory vaccination policy, or they can adopt a policy that provides employees with the option of not getting vaccinated, but testing before they come into work and wearing a mask when they come in. And if you are thinking which one is best for your workforce, uh, one thing we are seeing is generally high rates of vaccination. But if your workforce is not highly vaccinated, you might want to consider collecting their vaccination status and using that to see how will this affect our workforce. We're seeing a lot of employees resign if they have to get vaccinated. So maybe that would encourage you or be a consideration that you take into account that leads you to adopt the test and mask alternative. So OSHA has given us some guidance on what our vaccination or test and mask policies have to say. And OSHA has actually put out template policies that are very good, and they have placeholders for specific references to the employer's current policies, a cross-reference to a sick time policy or a cross-reference to a discipline policy. But the substance is all there. So I encourage you to take a look at those, if not to begin fitting them to your business so that you're prepared when the deadlines come, if they do come, just so you can kind of see what OSHA would expect. But at a high level, the elements of an effective vaccination policy are on the slide now. And the first is you have to explain in your policy what the requirements for full vaccination mean. You have to explain that it's FDA approved vaccinations. You have to say 2 doses of Moderna or Pfizer, 1 of J&J. You have to go through all of that and explain exactly what full vaccination means. The next thing you have to do, which I think is one of the most important things, is to expressly set forth the applicable exclusions from the written policy. The ETS expressly says that the employer has to make exceptions for medical contraindications, medical necessity that requires the delay of the vaccine, or reasonable accommodations for workers with disabilities or sincerely held religious beliefs. The third element of an effective vax policy is information on determining an employee's vaccination status. You're going to have to tell them the data or the documents they'll have to produce to determine whether or not they're vaccinated, and you'll have to tell them how you'll collect this information. A key requirement, and OSHA pushes this requirement hard. It's in all of the fact sheets. It's a subject of 2 or 3 FAQs. It's on their website, is paid time off of up to 4 hours for the vaccination and reasonable time off to recover from the adverse effects of the vaccination. Now, the ETS doesn't say what reasonable time off means, but in the FAQs, OSHA says that it will assume that 8 hours per dose of the vaccine is reasonable for a total of 16 hours of recovery time. So if you follow that, you're safe under OSHA. If you go a little less, it's not that you aren't safe, it's just you're not going to get the benefit of OSHA's presumption that the time off you're providing is reasonable. You're going to have to tell your employees in your policy the consequences of a positive COVID-19 test. And you're going to have to expressly inform them that they will be removed from the workplace if they have a positive test. On this point, you want to note in your policy that covered employers have to require their employees to promptly disclose when they have received a COVID-19 positive test or they've been diagnosed with COVID-19 by a doctor. And you have to tell them that they won't be permitted to return to the workplace unless one of the following three conditions is met. First, a negative test result obtained as a result of a rapid test, or they followed the CDC's guidance on self-isolation after the diagnosis or positive test. Or finally, a healthcare provider, a licensed healthcare provider, recommends that they may return to work. If one of those three conditions is satisfied, you can let an employee come back to the workplace. One thing to note is the ETS does not explicitly require employers to provide paid leave in the event of a positive test. Remember, it's just to get a vaccine and to address the side effects of receiving a vaccine. But you'll have to look at your existing policies, state and local laws, and if you have a unionized workforce, your collective bargaining agreements to see if there's any requirement for you to provide paid leave in the event of a positive test that precludes the employee from coming into work. One thing that you do not want to overlook in your policy, and the OSHA policy actually has a reminder about this, is disciplinary actions. The policy should expressly inform employees of the results of failing to comply. So if you roll out a test and mask policy, you'll want to let employees know, hey, if you don't get a test by the time set in our policy, which we'll go over in a minute, you're going to suffer, consequences X, Y, and Z. I recommend cross-referencing your pre-existing progressive discipline policy. But if you wanted to take a harder line and say, failure to test that was within your control will result in automatic termination, you can take that hard line if you like.
And Fran, would that be an area though for them to be careful if they're in states that maybe, like the Florida, what they're passing to say you can't fire somebody if they, didn't meet it, that you had to do the testing?
Yeah. So if you're in a state that puts that kind of restriction on you, that is going to be a really novel legal question, because the OSHA ETS says it preempts any law that is contrary to it. But the OSHA ETS doesn't expressly say you have to fire people if they don't test, you have to fire people if they do this. So the question's going to be really nuanced, and it's going to be, does Florida's order stand in the way of an important federal policy? And there's an argument that it does. So that is just a risk to be aware of. And if you are confronted with that situation when the ETS takes effect, if it takes effect, that's something you'll want to talk with counsel about. So there are two more things, and this is just common sense type stuff. You will have to mention in your policy the effective date and the deadlines for compliance, just so employees are on notice of what they need to do and when they need to do it by. So now that we've talked about the policy requirement, let's talk about the requirement to promote or encourage vaccination among our workforces. So the first way OSHA has deemed employers responsible for promoting vaccination is to provide time off to receive the vaccine. We talked about this just a minute ago, but time off to receive the vaccine also includes ancillary activities such as traveling to the vaccination site and registering for a vaccination appointment. And we talked about the time off to address the side effects as well. Note, this is an important note, to satisfy the time off provisions, you can use an existing sick leave policy. But if your existing sick leave policy doesn't cover this, or if an employee has exhausted time under a pre-existing policy, you'll have to make paid time available to employees outside of your sick leave policy. The next thing employers have to do to inform their workforce of the vaccine and to promote it is to expressly let them know about three things. The first is what the ETS says. And on this, OSHA has prepared a really helpful fact sheet for workers. which I think is helpful, but I don't think it's the full picture, and we'll talk about that in a second. The second thing employers have to do is they have to inform their employees of the policies and procedures the employer has adopted to implement the ETS. So the COVID vaccination policy that we talked about on the last slide. And the final thing that you have to do as an employer is you have to provide employees with the CDC's pamphlet about vaccines and vaccine safety. I mentioned that the OSHA workplace flyer that they've prepared is a helpful start, but isn't the whole picture. And the reason for that is it's just a piece of paper, and OSHA's ETS, and more importantly, the FAQs make clear that OSHA is contemplating training, not just handing out flyers. OSHA wants training, and they want some kind of record or proof that employees comprehend the training. So you have to give the training in a language that your employees understand. So if your workforce speaks multiple languages, you'll want to consider giving it to them in the languages that they understand. You'll have to prepare it at a literacy level geared toward your workforce. And if you have a diverse workforce in terms of C-suite executives down to hourly employees, arguably you'd have to give different training or instruction to different segments of your workforce. The training, however, there isn't a one-size-fits-all approach. You can do it in person, you could do it virtually, you can have an instructor, you could have a self kind of assessment where you click through slides and maybe answer questions to demonstrate comprehension. That part is up to employers, so long as that it's geared toward employees in a language and at a literacy level they'll understand. And finally, I mentioned you'll have to show that employees comprehend the training that they've received. And OSHA, again, is leaving this up to employers. They said you can do it orally through a Q&A with employees, or employees can just say, oh, I understand, and I don't have any questions. I think that is a good start to have employees ask questions orally, but I'd like something in writing, whether it's a kind of interactive test during a PowerPoint where they have to, check boxes or fill out multiple choice, or whether it's a certification at the end that says, I acknowledge I've gone through the company's COVID-19 training and I understand it and I've had any questions answered to my satisfaction, or whether it's a written quiz. I would want something in writing so that if OSHA ever does come to us and say, hey, your workers don't understand their obligations, we could say, well, no, right here is our records of training, and everyone seems to have got it. So I'd like it in writing. And on this point, I'm actually going to pass it over to Christine briefly to talk about some things Higher Image is doing to help employers comply with the promotion of the vaccine requirement.
Yeah, I just, in our program, we're sending out alerts to the employees for uploading their vaccination cards, or if not, claiming their exemption. So it's real easy, whether it's our system or a system you're using, to just include the link to that key things to know about COVID-19 vaccines. Super easy. Just kind of put it at the bottom of your email. And that's what we've done. We've just kind of made it a default. So you would meet that.
So let's talk about the third and final December 5th deadline, and that is to collect and maintain documents concerning our employees' vaccination status. So the ETS says employers have an obligation to collect acceptable proof of vaccination. And it goes on to define what acceptable proof means. It could be medical records, it could be a vaccination card, it could be a public health record, it could be any number of things. But if an employee can't produce acceptable proof, then the employer has to allow them to provide a written verification that is signed under the penalties of perjury that says, I've lost my proof of vaccination and I affirm and swear that I am vaccinated. If an employee doesn't produce acceptable proof and doesn't sign that verification, then you have to treat the employee as not being fully vaccinated.
And Fran, what are your comments on that for, what level is the employer responsible to know if the card is a fake or not? There's news stories out there that there's a lot with NYPD that there's, sharing cards. And so what onus is put on the employers, do you think, for, proving if the vaccination card is real or not real?
That's a really good question. And I've been getting that question as well. And so what I've been saying is the ETS doesn't tell us what the employer's obligation is, but in the notice of rulemaking, so the ETS is a set of rules, but it's preceded by a notice of rulemaking that OSHA issued, and that has OSHA's commentary and its reasoning on why it thinks the ETS is important. And buried in there, that's like a 50 or 60 page document with 3 or 4 columns per page. It's very dense, and buried in there in a footnote is a comment about this. And it says, if an employer knows that proof submitted by an employee is fraudulent, and even with this knowledge accepts and maintains the fraudulent proof as compliance with the ETS, it may be subject to the penalties for perjury set forth in the OSHA statute. And those penalties range from hefty civil fines to even criminal penalties. So OSHA says it's a knowledge requirement. To avoid any kind of issue, I would say just act in good faith. If you get something that it has a name scribbled out on it, or if it looks like a duplicate of something you've already received, or if it's printed on computer paper and it's off center or something, if it doesn't pass the smell test, I would say take steps to verify it, because what you don't want to do is you don't want to collect it and say, I, the employer, take this as proof of vaccination when it's false. And OSHA could say you had a reason to know that it was false.
We had somebody who submitted a card and they spelled Moderna wrong. So that was.
So that's a red flag, to say the least.
And I did hear Wisconsin is the first state to have some sort of registry that you can actually look up, which wouldn't that make it easier on employers if they had somewhere to actually look up someone's status if they're going to have to comply with this. So I like the good faith effort. And then on this slide too, I had another question on that comes up quite a bit. So if you have remote employees, they're not required to get vaccinated. Do you want to collect their cards? Do you want that to go into your numbers that, if OSHA asks for a report on what percentage of your workforce is vaccinated, what do you do with those kind of workers that maybe don't fall under the requiring the vaccination card?
So I do want to collect their cards by the December 5th deadline, or, if the state pushes it out, whatever that deadline might be, I want their cards by that deadline, because the ETS doesn't exempt remote workers entirely. It exempts them while they're working remotely. And what we don't want is a situation where a remote worker, is going to come into the office on a day, maybe for a team meeting or something, and we don't know if they're vaccinated, and we don't know what to do with them under the ETS. So I'd say collect them now, and it also helps you understand the full portrait of your workforce. The good thing about the stay is it gives us a little more time, most likely, to make decisions about complying with the ETS. So are we going to roll out mandatory vax, or are we going to say test and mask? And if we see, if we collect our remote workers cards and we see that they're for the most part vaccinated, and the same is true of our workforce, well, let's just do, mandatory vax. It's not going to have that much of an adverse effect on our workforce. It's really not going to impact anyone. So you can kind of use that information to help tailor your decision making. So what do we do once we collect the proof of vaccination? Well, we have to do two things. We have to preserve the proof. So you don't have to keep the original, but make a copy of it and save it in a file. And we'll talk about where that file should be in a second. And the other thing you have to do is you have to maintain a roster of the acceptable proof that you've received. So think of maybe an Excel spreadsheet or something like that has employee ID, employee name, whether they provided proof, what they provided, when they provided it, just something documenting all the information about the proof that you've received.
Fran, just a quick point. Scott brought up a great point. Although the employer can't look, Rhode Island Department of Health has where the person can get their copy. If they lost their card, can't find it, then that's a, acceptable documentation. And someone else did ask a question about, they were asking for, proof of vaccination, but they didn't collect the cards. Could they be grandfathered into having the cards if they don't really physically have them under this ETS?
No, so that's a good question. No, if the ETS takes effect, if the stay is lifted, you'll have to preserve the proof that you collected. So you'll have to go back and do it all over again, unfortunately. And in terms of storing what we've collected and our roster that we put together, these are confidential medical records under OSHA's regs. So OSHA has a record keeping statute. It's pretty onerous. The big points are you have to keep these records segregated out of the employee's personnel file. You have to limit access to employees who have a need to know basis. And you have to maintain them for a certain period of time. Now, the OSHA record keeping reg requires employers to maintain medical records for, well, some are up to 30 years, most are 5. The ETS doesn't go that far. It says you have to treat them like a medical record, except the timing requirements. We're going to reduce those for you, and you just have to keep this information and preserve it while the ETS is in effect.
And Fran, can you just discuss, because there's been a lot of confusion about privacy and medical records versus HIPAA. Can you just kind of touch on that for a minute?
Yeah, sure thing. That's a really good question that comes up a lot. As a general rule, HIPAA does not apply to employers as employers. It applies to covered entities, which are healthcare providers, insurance companies, certain types of benefit plans, but it does not apply to employers as employers. So we don't have to worry so much about HIPAA, but we do have to worry about the OSHA record keeping statute, which, like I said, is very strict. It's not HIPAA, but it's still pretty strict. And one thing to keep in mind is you can tell your workforce, 78% of our workforce is vaccinated, or whatever the case may be. But what you can't do is you can't say, and Joe Smith, who sits in the cubicle on floor 3, is not vaccinated. You can't divulge the information that you receive from an employee concerning their vaccination status.
Fran, would you mind weighing in on, I struggle with how employers are going to do this, and that's what we're building into our program. But, this is this point in time that I have this over 100 employees and I'm collecting the cards. But obviously I have people who leave my employment. I have new people I'm hiring. Kind of what is that record keeping? Like, I know I have a very short window for OSHA if they come and ask for a report, if this all holds. Do you have any guidance as to how often should the employer kind of be, updating that kind of tracking for OSHA? Obviously it can't be, it's not going to be exact every single day. So.
Right. So you can't update it every single time somebody gives you a card. If someone, gets vaccinated after you do your initial collection. So what I'm recommending is do your initial collection if you're in a state that allows it. So that's the first thing. Rhode Island, it's fine. Other states, you might have to look. But do your initial collection. And if you're getting cards trickling in after the fact because you have a test and mask policy, you're not doing mandatory vax, and somebody changes their mind, I'd say update it, pick a day of the week to update it at a reasonable interval. And if OSHA comes and they ask for your records, you only have 4 hours to get it to them. So it has to be accessible. Your records have to be accessible. You want to minimize access to them. So you don't want to put them on a company-wide, Google Docs or share file, obviously, but you might want multiple people in HR, compliance, maybe legal, to all have access because if OSHA comes and only one person had access and that person's off or in a meeting, well, now we can run afoul of the ETS by not turning documents over in time. And in terms of updating it, if OSHA comes knocking and they say, we want to see your roster, I think you turn it over promptly and you just say, we update our roster as a matter of a routine practice every Friday. We haven't done the update for this week. We'll supplement our production to you when we do the update, or we'll even try to do it earlier just for you, OSHA, just to show that we're trying to act in good faith. That's how I would approach it. I wouldn't go crazy and update it every time a card comes in.
Right. And that 4 hours to me is crazy. But also in there, I know there's where an employee can ask, or an employee's representative can ask. Can you just talk a little bit about that? Because I had some folks that were concerned, I have to give the whole listing and who's vaccinated and who's not. Can you just talk about what that requirement is if an employee asks?
So if an employee asks, they're not entitled to any confidential medical information of another employee. So they don't get to see proof of vax for someone else. They don't get to see the roster. But what you can tell them is you can tell them, X percentage of the workforce is vaccinated. But if you do more than that, you run into trouble under the medical record regulation.
Fun for employers, that's for sure.
Isn't it? So the next requirement that OSHA's requiring is face coverings. So if you do a test and mask approach, unvaccinated employees are going to have to wear a mask while at work, unless you can fit into one of these very limited exceptions. If they're working outdoors, they don't have to wear the mask. If they're working alone in an enclosed room, it has to have a door. They don't have to wear a mask. If they're actively eating and drinking, so they can't just leave a water bottle on their desk all day and say I'm drinking. It has to be an active exercise. They have to be actually eating or drinking. If they work in a situation where they have to wear PPE, such as a respirator or face mask, they don't have to wear a face covering on top of that, obviously. And finally, if the employer determines that an employee's wearing a face mask would actually pose a greater risk of hazard than the face covering mitigates, the employee doesn't have to wear the face mask. So if they're working around something flammable, or if they're working in closed quarters where breathing might be a little difficult, if they're in a tight, warm space, they don't have to wear a face mask. Now, while unvaccinated employees have to wear a face mask, employers cannot prevent employees, regardless of vaccination status, from wearing a face covering, except in a limited circumstance where doing so would create a hazard. So if a vaccinated employee says, I'm more comfortable wearing a mask, you have to let them wear a mask unless it would be dangerous for them to do that. So now let's move on to our January 4 requirements. So here are the requirements for unvaccinated workers. They have to be tested once every 7 days if they report to work once every 7 days. If they're on a different schedule and they report to work less frequently than once a week, they just have to be tested within 7 days before coming into work. Now, there's no testing requirement for employees who have had COVID-19 or a diagnosis of COVID-19 by a licensed medical provider within the past 90 days. Employers must collect and save records of any COVID-19 test result that an employee provides or that the employer obtains through its own administered test. And it has to treat those test result records just like the vaccination record, so that they're subject to OSHA's medical record keeping regulation during the period of time the ETS is in effect. And one final point, and this is a big point, I'm getting a lot of questions about this, and I'm sure a lot of you have started thinking about this, or maybe have received questions about this yourself, and that is, if we do test a mask, do we have to pay for the tests? So under the ETS, there's no requirement for an employer to pay for the test. So you'll have to look at state law, or if you have a unionized workforce, your CBA requirements. Now, in Rhode Island, we don't have a statute directly on point, but I could see employees getting creative and pointing to two different statutes to try to say there's a requirement to pay. The first is what we all call the drug testing statute, and that's kind of a misnomer because it's not a drug testing statute. It's actually called the testing of urine and blood and bodily fluids statute. And a COVID test could potentially fit within that general rubric. And in that statute, the legislature made clear that employers have to pay for any of those tests. Now, my argument would be read the statute contextually. It's not about this. It's about testing for impairments like drugs and alcohol in the workplace. But I do think there is at least an argument there. There's also our payment of wages statute. And fortunately, unlike Massachusetts, we haven't had a lot of unfavorable rulings on that statute. It has not become a really hot button issue, but it is starting to be. So I can see someone saying under the payment of wages statute, you can't pass business costs along to an employee, so you have to pay for it. And my argument there would be, we haven't had a case that says that. It doesn't expressly say that in the statute. And strictly speaking, this isn't a business cost because knowing your vaccination status also helps you outside of work. So I think, again, someone might try to make that argument, but it's not a hard and fast requirement under the statute. And I think it's relatively low risk not to pay employees for the costs of taking a COVID-19 test. And finally, I mean, just tell them to go to a free testing site. You can sign up for a free test on the Department of Health's website anytime you want. So if they're getting paid tests, it's kind of unnecessary. Now, the rule is most likely different for employees offered testing as a reasonable accommodation. So let's say you don't roll out test and mask, you roll out mandatory vax. An employee comes to you and they say because of a medical condition or a religious belief, they can't receive the vaccine. In that situation, the general rule is that an employer has to pay the costs of a reasonable accommodation. So there, you most likely would have to pay. And that could be another reason, if you're considering where do we go, mandatory vax or test and mask, this could be another reason that the scale tips in favor of test and mask, because under test and mask, we're not giving an employee a reasonable accommodation to test and wear a mask. That's the policy. So that might be one way of looking at this and trying to minimize the cost. We're treating you just like everyone else. If you don't get a vaccine, then you have to get a test and mask at your own expense.
Fran, I'm just looking at the time and I want to make sure you get through everything. And I think I have a bunch of questions on here that have come up, but I almost feel like depending on what happens with the core challenges, we might have to have just a testing conversation about this ETS as things roll out. So I'm going to hold those questions and we'll let you move on to.
Of course. And are we going to 1:15, Christine?
Or was it 1:15? Scott?
Is correct.
Oh, okay. My bad.
Yep.
Look at me. Thank
Okay.
God Scott's here to keep me honest. Well, good.
So, and a note on testing. Earlier, I mentioned if an employee fails to test and it's because of something that was in their control, they just forgot about it and they didn't go to a clinic on time or something like that, they can be disciplined for that, and you should discipline them for that so that you're enforcing your policy. OSHA expects us to enforce our policies, but OSHA is taking a more practical approach, and when an employee comes to work and says, I couldn't get a test because, the clinic was out of tests or something like that. So OSHA says if the employee comes to you and the employee has a reason outside of their control for not getting a test on time, OSHA is saying it's not going to automatically issue a citation for that. If you let the unvaccinated worker work that day, OSHA is not going to cite you. Instead, it's going to look at your pattern and practice of enforcing your test policy. And so that's why we want to put progressive discipline in the policy, or disciplinary ramifications. And that's why we want to enforce it. Because if we do have this one-off situation where an employee couldn't test for a reason solely outside of the employee's control, we can tell OSHA, hey, don't issue us a citation for letting this person on the job site. Look at our pattern and practice. We don't do this often. In fact, we've never done it before. We disciplined every employee who came to work without a negative test result. You want to be able to point to that to avoid a citation.
So since we had a couple extra minutes and you answered some of the questions within what you just said, but what about if, somebody did miss their test for a week? Like, what do you recommend employers kind of for their tracking, or, should they just, OSHA didn't come this week, so I won't, we won't address it? Or what do you want them to do to keep, for record keeping purposes, someone just didn't go for whatever reason, to show that maybe they didn't come on campus? Or what are your suggestions?
So that's a good question. And a couple of things you could do. You could maintain a separate roster, a test tracking roster. It's not required, but you could do it. You could also document it in the form of a written warning, or anything you're doing in your progressive discipline policy, and saving that document in the personnel file. And that can go in the personnel file so long as we don't put medical information in there. So, you violated COVID-19 policy and you put it in the personnel file, something like that will be okay. But if you say you violate COVID-19 policy because you're unvaccinated and you didn't get a test, and your medical condition that you claim prohibits you from getting a test isn't real, blah, 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 you don't want to do things like that. So you can document it through performance or disciplinary warnings, or you could also have a kind of roster to track. I do like the idea of a roster, because if OSHA does want to see your pattern and practice of enforcing it, you don't have to produce, hundreds of personnel documents. Although you should have them. You should issue personnel documents like warnings when people do violate it, but you do want this roster just to shoot over an Excel file to the investigator and say, look at what we've done. We take such good faith efforts to enforce our policy. We document them all here. We're clearly not trying to do an end run around the requirement, OSHA. So I like that idea a lot. And speaking of compliance, let's turn on to our final segment of compliance considerations. And really, no discussion about compliance would be complete without addressing the elephant in the room that we've kind of alluded to, but haven't hit square on, and that is the legal challenges to the ETS. And this really starts, you might think it started last month or earlier this month when the ETS was rolled out and immediately challenged, but it actually started last year. In June of 2020, the AFL-CIO filed a petition in the DC Circuit Court of Appeals asking for an order requiring OSHA to issue an ETS that does almost exactly what this ETS purports to do. And the OSHA said no. It was under a different administration, and OSHA said, no, we're not doing it. We don't think it's necessary. We have a general duty clause that is flexible enough to allow us to protect workers who might be exposed to COVID-19 at work. OSHA also said, this is an evolving situation. We're learning more about the virus and how it spreads and how to contain it every day. And the last thing we want to do is tie employers' hands by issuing guidance or an ETS today that might not be correct tomorrow. So OSHA said no. And the DC Circuit, addressing the labor union petition, said, we defer to the agency. We're just judges. We don't know about health and safety in the workplace. OSHA does. That's OSHA's job. And if OSHA thinks that it can address this situation using alternative avenues like the general duty clause, OSHA says employers have a duty to prevent and protect employees from unreasonable hazards in the workplace. If OSHA thinks that's enough, we're not going to step on their toes. So we get that order. November 4th, 2021, OSHA issues the ETS. November 5th, it's challenged. And November 6th, the Fifth Circuit Court of Appeals, which is down in New Orleans, issued a temporary stay of the ETS. And it basically said, there could be some issues with this, and we need to think about whether or not we're going to require employers to comply with this. So give us some time to think. So they had that time to think. For about a week, the Fifth Circuit considered the parties' briefings. And the parties in that case, they were diverse. It was a collection of states, Texas, Mississippi being the two leaders of that state coalition. There were religious groups, there were individuals, there were public interest groups, there were employers or multiple employers. They all pooled their resources together to file this challenge. And they submitted various briefs from November 6th to about November 10th. The court reviewed them, and the court said, now we have an opportunity to put in place, we can get rid of our old stay, or we can put in place a long-term stay. And that's what the Fifth Circuit did on November 12th. The Fifth Circuit, and just by way of high-level background, the Fifth Circuit basically said two things. We're not sure this is an emergency. OSHA, in June, didn't think it was an emergency. We're not sure this is necessary. Remember, it has to be necessary to protect employees from a grave danger. We don't know if this is necessary because a large majority of Americans are vaccinated. And OSHA has other alternatives like the general duty clause that it can use to protect workers. And it cited that DC Circuit case from last year. And the last thing the Fifth Circuit said at a high level is generally the federal government doesn't impose personal decisions on people. That's a matter left for the states. And it cited cases from over 100 years ago. Actually, Massachusetts was the first state to do this. It cited a case from the Supreme Court, 1905, addressing a Massachusetts vaccine mandate. And the Supreme Court said this is a proper exercise of state authority. So the Fifth Circuit said when you look at all these things, the parties challenging this ETS, they have a reasonable chance of prevailing and defeating it. So we're going to hold it in abeyance. It's not going to take effect until we reach a final determination on the merits. The Fifth Circuit will not reach that determination because 2 days ago, the federal court system held a lottery and they randomly assigned all the challenges to the ETS. So the Fifth Circuit was one challenge, but there were 10 other circuit courts addressing very similar challenges throughout the country. So when that happens, for efficiency, we put them all in one court. Tuesday, that court was picked out of a hat, not literally, but pretty much at random. And that court is the Sixth Circuit Court of Appeals, which is up in Ohio. And that court will hear this challenge. It will issue a final order on this challenge and the 10 others that it consolidated. And just some inside baseball, the Sixth Circuit is an incredibly employer-friendly circuit. The Fifth Circuit is probably the most employer-friendly circuit, but the Sixth Circuit is in the running for number 2. It has 16 judges, and 11 of them were appointed by Republican presidents. 5 were appointed by President Trump. And its chief judge is a former law clerk to Justice Scalia, who's one of the most conservative justices to have ever sat in the Supreme Court. And not only that, he is widely considered to be Scalia's best law clerk and his protege in a number of ways. So that's where the case is now. All that being said, there are good reasons for employers to at least take preliminary steps at compliance starting now. And the first is there is ambiguity as to the status of the December 5th deadline and the January 4th deadline if the stay is lifted, and even if it's not lifted or before those deadlines. If it's lifted after, we don't know what happens to those deadlines if the stay is lifted and the ETS takes effect. OSHA could have said something very helpful on its website, like, we understand that the Fifth Circuit has state enforcement of this, and we're going to toll the deadlines during the same amount of time the ETS is in effect. So if the ETS is in effect 30 days, we're going to push those deadlines out by 30 days. It didn't do that. Instead, right after the Fifth Circuit issued its ruling, OSHA said, we believe the ETS is valid and it was a legitimate exercise of our authority. But because we have to comply with the order, we're not going to enforce it while the order is in place. So it doesn't really tell us anything about what happens if the order is not in place. Another reason to act now is the penalties for non-compliance can be significant. So let's say the stay is lifted, and let's say we have to get into compliance pretty quickly. The penalties can be steep, up over $13,000 for one violation. So arguably, if you have a workforce of 100 employees and you didn't collect one card, that's 100 violations. If OSHA says you're on notice of this violation, here's a citation, you have so many days to abate it. If you don't abate it by that deadline, it's another $13,000 or so per day that each violation is not abated. And if OSHA finds willfulness or repeated violations, and willfulness is a high standard, but if they show that you had knowledge and you ignored your obligations, the penalties can go up to over 130,000. So the penalties can be steep. And the final reason is I read that Fifth Circuit case. So I've read the cases, I've read the ETS, I've read the fact sheets, I've read the FAQs, so you don't have to. And it kind of consumed as many pages as the books that are behind me. It was a lot of reading. But when I read that Fifth Circuit case, one thing jumped out at me, and that was the reference to that case that's over 100 years old, but it's still the law, that case from the Supreme Court saying Massachusetts can enact a vaccine mandate. When I saw that, the first thing I thought is states that are interested in this type of mandate could pick up on that language and say, if OSHA can't do it, we can. And the Supreme Court has already said we can do it. And it said it 2 or 3 times. And the Fifth Circuit, who said OSHA can't do it, has even hinted that we can do it. So we can do this. So that, to me, suggests we might see potential state action modeled on the ETS, and there would be grounds to challenge it possibly, but at least there wouldn't be that ground that the ETS is currently being challenged on. So one thing I'm telling my clients is to follow this kind of compliance checklist. There are things that you can do now while the ETS is not in effect to kind of get yourself prepared at very little cost and not that much time to come up to speed with a few requirements so that if it does take effect, you can move promptly. So I'm basically telling clients, implement, but don't enforce. So start doing things like look at your workforce. Do you have 100 employees? And take a hard look at your independent contractor relationships. Are they truly independent contractors? And now's a great time, even separate and apart from the ETS, now's a great time to do an independent contractor audit. The administration, the Biden administration, has independent contractors squarely in their crosshairs. So this is, even if it's not for the ETS, you can do an independent contractor audit now and really get a sense of what your workforce looks like. Consider integrated employer. Again, Secretary Walsh has said multiple times that he is going to revisit the integrated employer standard. And we have agencies like the NLRB doing the same thing. And OSHA is part of DOL under Secretary Walsh. So they're going to be revisiting integrated employer anyway. So this could be something that pays dividends separate and apart from the ETS, but it's something you can do now. Another thing you can do, collect your employees' vaccination status. It's not that difficult to have employees respond to a survey and upload proof of vaccination. It takes a few minutes per employee. And for the most part, the states don't prohibit this. You'll have to look at your state law because the ETS is not effective. So it doesn't have that preemptive force. If a state law says you can't ask an employee about vaccination status, then don't. That's the safest approach. But if you're in a state like ours that doesn't prohibit that, it's a small lift to ask for employees to provide their proof of vaccination now and start getting your roster. And plus, that'll help you determine what you want to do from a COVID-19 compliance standpoint, generally, separate and apart from the ETS. The third thing you can do is start thinking right now about what your policy is going to be and what it's going to look like. Start by looking at the OSHA template policies. They're good. I think they need some tweaking. They need to be tailored to your business, but they're a really good starting point. So start there and look at your sick time policies. Do they comply? Do you have to add to them? Think now about training, not just training your workforce, which we've talked about, but training managers and HR on the ETS. The three kind of traps for the unwary I see in the ETS from managers and HR's perspective is record keeping and documentation. Make sure they collect the records, make sure they save them properly, and make sure they don't disseminate them. I also see reasonable accommodations as being tricky. It always is, but I think it's going to take on heightened significance under the ETS because we've already seen way more reasonable accommodation requests than I've ever seen, at any one time. Nothing has prompted this many accommodation requests. And the final thing is the anti-retaliation obligations. Your managers need to know about that. And this is something, again, you can focus on the ETS, but I don't know if anyone saw the webinar that I believe was 2 days ago. DOL, EEOC, and NLRB had a webinar with the Solicitor of Labor and the General Counsel of NLRB, and I believe the General Counsel of EEOC and the Commissioner, talking about whistleblowing and retaliation is their focal point, and it is the number one way they intend to find and ferret out potential violations of the discrimination laws. So whistleblower and retaliation is separate and apart from the ETS, one of the hottest topics. I mean, this summer, Rhode Island amended its whistleblower law to expand its protections and provide for treble damages. So this kind of anti-retaliation training is good for the ETS, but also good as a general compliance practice going forward. Finally, consider whether your employees are represented by a union. The NLRB has said because the ETS gives you the discretion to adopt a mandatory vax policy or a test and mask policy, you have to bargain with the union over which one you're going to implement. So you want to consider that. And finally, the last bullet on the slide is just stay on top of what's happening with the ETS and the courts. These cases move very quickly. And they are highly publicized, so it's not very difficult to do. We're monitoring it. If you want us to monitor it for you and send you updates, we can do that, but something to stay on top of. So I think I'm at my time. I welcome any questions, but it was
Fran, you did a great job. I know the resource page you have too, and I think everyone's going to get the PowerPoint presentation, which this is chock full. I know in the chat, people were asking about the sample policies, which you have so kindly put in there as a kind of a one-stop for everybody. So that's awesome. So I'll kick it back to you, Scott, to wrap it up. But Fran, you did an awesome job. Thank you. I know so much to cover today.
Thank you. So great. So great, Fran. Thank you so much. So here's a quick question. What do you think will happen if it gets to the Supreme Court, and how long would the court take to rule?
So that's a good question. It's a tough question. I mean, this is just kind of my own feeling about it. I think the Sixth Circuit is very conservative. I think the Sixth Circuit is going to uphold the challenges. So I think it's going to affirm the Fifth Circuit decision and deny some of the challenges to the Fifth Circuit decision. I think it'll be appealed to the Supreme Court. The Supreme Court doesn't have to hear cases. It can always decline a case, but I think it will hear this one because it's so important. And just looking at the composition of the court, there's a good chance they strike down the ETS. I mean, it's just, again, this is my speculation. And one thing I'll note,
I understand that.
For anyone who's kind of like a legal nerd, in the Fifth Circuit opinion, the judge who wrote it did something very clever, and he cited decisions by 4 active Supreme Court justices, Thomas, Kavanaugh, Gorsuch, and Roberts, and he put their names after the cases, almost as a signal to, where this is going, and how you guys have ruled in the past, and that's why, affirm me. I don't want to be wrong.
Well, thank you so much. I know we were a little over our time, but we really, really, truly appreciate this thorough information. We'll get all this out to everybody that's on the call today and that was signed up, and we'll wrap it up here, and have a wonderful Thanksgiving, everyone. Thank you so much. Enjoy your
Thanks,
day.
Scott. Thanks, Fran.
Thank you. Thank you so much,
Happy
Scott. Thank you,
Thanksgiving.
Christine. Great job.